All right, almost finished here now. Let's turn to elections as a part of the constitutional system. Of course, we know we've already mentioned in class there are three elected offices in the Constitution: the House, the Senate, and the President. And you can see the description of the terms of office and how they're elected in each of the sections. Here's the Senate. Senate composed of 2 senators from each state, chosen by the legislature thereof for 6 years. Now you can see that this is italicized. It means it's been changed. It was changed by the 17th Amendment, which provided that senators would be chosen by direct election of the people, not through an intervening legislature, just like the House is selected. The president has been and was a subject of much discussion at the Constitutional Convention. We talked about that. They finally came upon the Electoral College, which is spelled out, of course, in Article 2, in the first section of Article 2. It was so ill-conceived that it didn't work from the very beginning. So they had to fix it. That's what this 12th Amendment is about, fixing the Electoral College, the language of it, technical fix. And there are 4 other amendments specifically dealing with either the election of the president or the succession of office. So fully one third of all of the post 1791 amendments had to do with the election of the president. 2-term limit here, electoral college votes for residents of D.C., succession. Also about elections, there are 4 constitutional amendments, another 4 having to do with who votes. This is women. The 15th Amendment is African American men, women, no poll tax, and 18-year-olds. So that means that something like half of the constitutional amendments had to do with the electoral system. Judicial review is also a very important part of the system. Judicial review is the power of the Supreme Court to declare laws unconstitutional, and this power is not in the Constitution. It's not mentioned anywhere in the Constitution what would happen if Congress passed a law that was unconstitutional. It's established by precedent. A case called Marbury versus Madison in 1803. Very early precedent. It's the earliest precedent in our system. And in that case, the Supreme Court struck down a law that gave the president a power it actually gave the court itself a power that was not in the Constitution. And so they struck down a law that was going to expand their power, but really in the long term they ended up expanding their power. The court did even more. So it's a pretty dramatic, of course, thing when a Supreme Court strikes down a law passed by all of our elected representatives. The 6th part of the system, individual rights. And individual rights, they make one appearance in terms of civil liberties, one appearance in the Constitution itself in Article 1, Section 9, the discussion of habeas corpus. Primarily, you'll find them in the Bill of Rights, Amendments 1 through 9. And we'll be talking about those for sure later. when we talk about civil liberties. Just take a look through them, especially this one here, religion, speech, assembly, press, petition that we talked about before. The Fourth Amendment will also spend time directly talking about unreasonable search, no unreasonable search and seizure. The Ninth Amendment is kind of interesting. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This was put in basically to make Madison happy. Madison was worried that if you put a Bill of Rights, a list of rights in the Constitution, that that would mean to people, that would signal to people that those were the only rights that people would ever have. And he was terribly worried about those 55 people not being, well, actually this is a couple years later, but the current people alive might not be able to think of everything and put in all the rights that they thought that the people should have. So he convinced them to put this this amendment in case they came across any others. Just the fact that there's a list of rights doesn't mean that there might not be some others that the people also have. There's really only been one right ever added to this list, and that's the right to privacy. And so he was kind of right. Other rights have been proposed and or suggested, and the Supreme Court has said, no, that's not on the list. Okay, and Amendment 10. All right, and finally, equality. Equality, the word does not appear in the original Constitution. It was not really on the radar screen for the people in Philadelphia. And it doesn't appear in the Constitution until the 14th Amendment is added in 1868. You can also think of the 13th Amendment as important for the issue of equality. The 13th Amendment, the 13th Amendment banned slavery. These are the Civil War amendments. The 13th Amendment banned slavery. The 14th Amendment is the Equal Protection Clause, the Due Process Clause. And the 15th Amendment gives the right to vote to African American men in 1870. And we mentioned that up here as well. Prohibition, of course, made a brief appearance in the Constitution. But one of the takeaway messages that I want you to think about is the fact that all of this and all of these amendments as well are procedural in nature. Prohibition was really the only attempt to settle some kind of policy question in the Constitution. And it didn't work out. We ended up taking that out. So all of these are really procedural questions. Who gets to participate? On what terms is the game going to be played? And policy questions are left for